Welcome back to Simple Money, the podcast that gives your personal finances a little bit of lovin'. I hope that everyone's been enjoying this podcast so far. Today we have another great episode. So, one of the unique aspects of this podcast is that we explore current events that will impact your personal finances. So, this includes topics like regulatory changes, news stories, and social issues that will affect you. Today, we're going to focus on some massive changes to your employment rights in Ontario. As some of you know, a bill was just passed at the end of November that will make some very large changes. Unfortunately, a lot of this dialogue was missed because included in that same bill was the highly controversial minimum wage changes. So this discussion really eclipsed all other changes that are included in that bill to your labor rights. So understanding these new rights can help protect you and those that you care about. The first big change is to maternity and parental benefits. This change allows families to have the option of taking their EI, parental benefits, for 61 weeks at a reduced rate of 33% of average weekly earnings. So now parents can choose between this option or the traditional 35-week option at 55% of average weekly earnings. Similarly, maternity benefits have also changed, so now mothers can start their benefits up to 12 weeks before a child's expected birth date. This is up from the previous 8 weeks. So these changes were actually passed by the federal government a few months back, but only now apply to all workers in Ontario now that Ontario has made these amendments. So number 2, personal emergency leave. Beginning on January 1st of 2018, workers will now be able to take 2 days paid and 8 days unpaid in cases of personal emergency. So what counts as a personal emergency? Well, it's typically classified as when you're falling ill, when you become injured, or if you have a medical emergency. This also applies if you have a spouse or a close family member with a similar problem. So the next big change is to employee misclassification. This is actually a really big one. This policy attempts to tackle employers that classify their employees as contractors instead of employees. This has been a very serious problem because these employees that are misclassified may not be able to qualify for specific benefits and may lack job security. So now what's happening is that employers now have the burden of proof to show that an employee is a contractor and not an employee if challenged. The next big labor change is one that's very welcome, and this is the elimination of mandatory high heels. This issue has been most rampant in the hospitality and restaurant industry. Simply put, they were forcing their employees to wear high heels, and if they weren't, they were often discriminated against. High heels have been linked to health issues, so this is a very, very welcome change. Now, there are some exceptions to this change. For example, if heels are needed for safety, or if the employee is in the entertainment or marketing industry. Next up is family leave. Beginning on January 1st, 2018, employees will now be able to take up to 28 days of leave to care and support certain family members that are at risk of death within the next 26 weeks. This is obviously going to be a growing concern as the baby boomer generation ages. The next big change to employment law is something that's titled Equal Pay for Equal Work. And what this is that now, or beginning on April 1st, I should say, temporary employees will soon be required to be paid the same wage as what their full-time counterparts would receive if they were doing comparable work. This rule applies to all part-time, casual, temporary, and seasonal employees. However, exclusions do exist, so when there is pay discrepancy based on seniority, merit, and a few other reasons, there can still be gaps. And the last big change that we're going to discuss today is the addition of scheduling protection for employees. This begins on January 1st, 2019, and protects workers that are on call and do shift work. There are a few different components to this policy, but the main one is that employers must now give 48 hours cancellation notice before shift start time. If they don't, they will be required to give 3 hours of pay to that employee. Also, there is no repercussions if an employee decides to refuse to work a shift with under 96 hours of advance notice. So that's it for now. I hope you find this information helpful. And always, thanks again for listening to Simple Money. Talk to you soon.